is calling 2022 CR 3745, State of Texas versus Joseph Harris. Can I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
Cornelia Scott.
And are you Mr. Harris? All right, so my understanding is this defense is calling investigator Carrie Kearns as a witness. Is that correct?
That's correct.
All right, just so everyone knows, when I was in private practice, I would always use Ms. Kearns as the investigator for cases that I was involved with. Ms. Kearns, she and I have had lunch together. I do consider her a friend. I will tell both parties that I can be fair, and I will base my decision upon the facts that are presented to me and not my relationship with Ms. Kearns. So is there going to be any objection to me hearing this state?
No, Your Honor, she was the investigator during the trial and no objection from the state.
Defense?
Okay.
All right, so we're here on defendant's motion for a new trial. And defense, it is your motion.
Okay, thank you, Judge.
And Mr. Harris, if you'd like to step down, you're more than welcome to do so as well. And the court will note for the record that Mr. Harris is present.
Okay. All right, we would like to first call Ms. Kern.
All right, Ms. Kearns, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand if you'll state your name for the record.
my name is Carrie Kern, Kerri, Kern, Kern.
All right, defense?
All right. And Ms. Kern, you were sometime during the trial in this matter, you were appointed an investigator, correct? As
That
an
is correct.
Okay. And did you attempt to find a witness, in this case by the name of Ruben Vasquera?
Yes.
I think that's how you last name. So V as in Victor, AQUERA.
No, I thought it was Vaquera.
Oh,
That's correct.
Yeah.
VAQURA, is that correct?
V as in Victor.
Vasquera. All right. And you made some attempts to try to locate that witness.
That is correct. I've spent a lot of time trying to locate him.
Okay. And were you successful in any of your attempts to locate this witness?
No, not to locate Ruben.
Okay. So you did you have a opportunity to review the statement that he gave the San Antonio Police Department with reference to this case?
Yes, I did.
Okay. Well, at this point, for the purpose of this hearing, would like to offer space. I'm sorry, defendant one. I've shown it to say they actually have a copy of it because they're the ones that gave it to me in discovery for the record, but I'm showing it to him again. Actually, I'm going to offer it in the evidence for the purposes of this hearing.
All right, any objection?
No, Your Honor, defense exhibit number one is the written statement made by Ruben Vaquera.
All right, and then the court then will allow the admission of defense exhibit number one, and the court will note that defense exhibit number one is included as an exhibit in the defendant's motion for a new trial.
Okay. Now, Ms. Ma'am, when you were seeking to locate this witness, you had an opportunity to review the statement, correct?
Correct.
Okay. And based on your experience of being an investigator, the importance of the purpose of this particular witness, were you able to determine in your experience any importance as to this particular case for this particular witness to testify, if you could locate him?
By reading his statement, it is, I can say for sure, definitely, we needed to interview him to get some clarity on a few things. And based on his statement, I think he needs to testify.
Okay.
Because he has a lot of knowledge.
Would you agree that he gives a vantage point, at least at the very, even the beginning of the statements, of what the defendant in this case did or may have said, and what was said to him initially during the confrontation?
So if I did watch the video too, and if I recall correctly, he stated he was sitting right behind Mr. Harris, and he heard everything that the Hispanic young boy, that's how he refers to him, what he was saying.
Okay. What the lengths did you take to try to locate this witness?
So I immediately ran a comprehensive background check that gives me like everything: cars, last known address, his current address, his cell phone, this, that, and the other. And so I took from that and started contacting the cell phone numbers and and then the two addresses here in San Antonio I went to, but I didn't have any luck there. Then I believe it was maybe that Wednesday or so, I had finally gotten in touch with a family member, his grandfather. And his grandfather did explain to me that he had moved back to Austin, but the family had not heard from him in several months.
All right. Did you try to make contact or reach out to anyone or anybody or any sources in the Austin area?
No, we had gathered some different addresses from the Austin area, and we just went to each one, and either they didn't know him, never heard of him, or there was no answer.
Okay. I'll pass it.
All right,
Yeah, you're on.
yes.
Good afternoon. Nice to see
Hello.
you. You stated that you watched the video, right?
Correct.
Of the shooting?
No, I watched it was a body worn camera of an officer standing next to him, and he was talking with them.
Okay, so I guess my question was, did you actually watch the surveillance video from the Via bus?
The only time I saw that video was when we were in court.
Okay, and did you see Mr. Ruben Vaquera in that video?
I don't recall, I wouldn't have been able to make it out because the screen was too small, and I wouldn't have been able to determine who was who.
Okay, but then you stated that Mr. Vaquera was sitting in back of the defendant, and tell me if I'm wrong, that's what I thought I heard you say. From that video, though, he was actually sitting in front of the defendant, Mr. Harris. Are you aware of that or not?
Okay, so I have not seen that body worn camera video in quite a while, but my recollection is that's what he had told the officers.
So if he would have told the officers that, he would have been wrong.
Well, I'm not necessarily thinking that he would be wrong as much as we just my recollection might be off. It's very possible that, you know, he was not sitting behind or in front. What did you say, front?
Yes, ma'am.
Yeah,
From the via security video, Mr. Vaquero was actually sitting in front on the bench on the bus stop, and the defendant and Jason Lexion were sitting behind him.
okay. Yeah, I have not seen the via video.
Okay.
Yes, so I'll take your word for it.
Okay, well, and then moving on, I know that I saw you in court, you were an investigator for defense counsel or the defense case, but did you listen to other witnesses such as Michael McDowell? He was an eyewitness that was standing on the bridge when the shooting occurred.
In court or watch his video, watch the discovery?
Actually in court, ma'am.
I don't think I was there for McDowell's testimony.
Okay, and he was an eyewitness. And then what about William Fowler? He was another eyewitness that was in the white pickup truck. Were you here for his testimony?
I don't believe so, no.
And then also a Gonzalez Salinas and also a Humberto Colon.
I was not there for their testimony.
All right. And did you ever look up a work history or employment of Mr. Ruben Vaquera to track him down?
Yes, what I did was he has several social media accounts that state a different workplace, and most of them are hotels in San Antonio downtown area. And I have several sources that work downtown in hotels who know just about anybody and everybody. And the only place that recognized him was the Drury Inn.
And let me ask, when did you start looking for Mr. Ruben Vaquera? Was
The week
it
of the-
after? I'm sorry, go ahead.
No, go ahead.
I was just asking, was it at the time of trial or was that previous to trial?
Time of trial.
Okay, thank you. No further questions.
Any further
Thank you.
Just a couple. Did you, ma'am, did you issue any subpoenas to obtain any medical records of the deceased?
Yes, I did.
Do you recall where those subpoenas were issued to? Which agencies?
The state, San Antonio State Hospital is the one that I subpoenaed. Hold on, let me grab my witness list here. And university. I apologize, university.
Okay, were there any secondary subpoenas anywhere else? The state hospital? Did you do that also? If you remember?
We say that again, please.
You send out any additional subpoenas to the state hospital? If you remember.
No, I believe I only issued one.
Okay. Would that be in your notes anywhere? If you had sent some out that were sent to the district clerk instead of directly to me?
Yes, it would be in my file, but I only issued one subpoena for the state hospital.
Okay.
Just when did you issue that subpoena or try to present it? Well, let me ask you just a quick question.
Okay.
I don't need an exact time. Was it after the trial started?
That is correct.
Okay, no further questions.
Yes.
All right, any other questions?
Not from this witness.
All right, is this witness excused?
Not subject to recall front by the state. Yeah.
All right, thank you so much for zooming in. Have a
Thank
good
you.
rest of your day.
Thank
You too.
Bye-bye.
In addition, Judge, I'd like to offer to number 3, number 2, that I presented to the state. And those are actually pictures of documents. not the documents themselves.
And Your Honor, no objection. I believe, I mean, Mr. Cox presented to me that these are the just pictures of the medical records that he obtained from, I believe, university that his investigator collected. So we don't have objections for the
Right.
purpose of this.
States
here.
exhibit number 2 and 3. I'm sorry, defense exhibits 2 and 3 is admitted without objection.
Right, just in those is not, I actually have the records with, that's over 500 pages of records that were requested prior to trial, who wasn't actually gotten to me until the trial had started.
All right, and these are records related to the complainant?
Yes, sir.
All right. All right, anything else from either side?
In terms of, no, Your Honor, in terms of evidence, that's it, and I'll just argue when it's at stake. I don't know if they're gonna continue.
We don't have anything to present, Your Honor, just argument.
All right, I'll hear brief argument.
Since,
Yeah, it's.
this is my motion, Judge, I'll waive opening and reserve everything for close.
All right.
That's fine.
State.
Judge, just since it's just fresh in your mind, the defense exhibit number 2 and 3, these records were obviously not requested by defense after the trial started by the investigator's own admission through testimony. But my understanding is he did receive, or rather the defense team did receive these records on at least by September 15th, which was on a Friday, before we broke for the weekend of Saturday and Sunday, and we restarted back up on Monday, September 18th. And so considering these records are, there are roughly 500 pages, but they're not thousands of pages. So it's something that could have been reviewed and subsequently was reviewed in the courtroom by many of us that were participating in this trial. So we don't feel that this is something that would hinder the defense's defense in this particular case. Addressing Mr. Ruben Becerra, I think the court is well aware eyewitness testimony is sometimes reliable, sometimes not. And in this particular case, the state brought forward no less than 4 witnesses that were eyewitnesses, well, at least 2 that were eyewitnesses to the actual shooting, one that was actually closer to the defendant and the deceased than Mr. Ruben Becerra, and actually had a better vantage point because he had no obstructions, because he was standing looking at each individual while the conversation, or rather argument, ensued there. And then we also have Mr. Fowler, that was an eyewitness that saw the defendant chasing down the complainant in this case and shooting him, and described that in very much detail as an eyewitness. We also had 2 different employees of buildings around that location that gave their rendition of what they saw immediately thereafter of the shooting and hearing the shooting. So in the case of Ruben Becerra, that he did give a statement that the state's position is somewhat inaccurate, because it doesn't follow the video, the via video that was entered into evidence. And if you read his actual statement and you compare it to that via video, it doesn't match up. And that's the case with Mr. Ruben Becerra. The state also looked for Ruben Becerra, was unable to find him or gain access to him. And I did mention that to Mr. Cox during the trial, that even before trial, I believe I mentioned that Ruben Becerra was not being able to be found by the state. And we did do our due diligence. We had looked for him for at least more than a month prior to trial, and through different sources that we looked through, including worksite sources and other sources. And that the state's position is that this motion for new trial should not be granted.
All right, defense.
Judge, my position is that when you, in terms of a defendant charged with a crime, there was some evidence that the complaining witness mannerisms and some things he was seeing was nonsensical. It was something that really didn't make a lot of sense. We tried to get to the issue of whether or not there was some mental health issues that he had. It's fair to see that from the discovery in this situation, to state they never delved into it or attempted to look into it, because if they had, they would have had to give that information to us. I can see that it appeared that they may have known there was a possibility of it, but they didn't delve into it. The problem you have is that you have, why Mr. Kara, guess how you pronounce it, that's probably wrong, but his statement at trial, if he was locatable, he was the one that was saying that this person was saying nonsensical things like, get off my block, I'm trying to why you're texting me. That didn't make a whole lot of sense. But as far as the defense, it would have showed something that there may have been a mental health issue with the complaining witness. Now, what happens is that we by not getting anything directly from the prosecution, we were just trying to locate anything from any other source that may suggest that there was an issue. We find it, but it's after the trial has started that the records actually came in. I requested a continuance on it. More than 500 pages, 500 pages that will show that not only did the complainant have mental health issues, that he had been hospitalized. There was an issue in this trial about a weapon, that the complainant actually bought a weapon. Now, what we learned later was that because if he voluntarily went to a mental health hospital, no matter what the diagnosis, you don't get the red flag. So you can go into a mental hospital for weeks or months, have bipolar, hallucination, anything. And if you go in there voluntarily, it seems that nobody flags him. So you can go out, you can leave the mental health hospital, go across the street, and buy any type of weapon that you want. In this case, the state indicated that during the trial that both parties were lawfully carrying, which was not the truth, because for the complaining witness, they lawfully carried them.
I just object to that portion, Your Honor.
Someone would have to be in a holster. Okay, so my position, Judge, is that by the 500 mental health pages of mental health records that we have that will show hospitalization, the defense was at a disadvantage in terms of preparing a defense that would bring more to light the mental health aspect of it, because with not having the witness Ruben Kara, not having him, when he would be, based on his test, based on his statement to police, that would show these type of erratic statements from somebody that we later found out had been hospitalized, severe mental health issues, more than one occasion. We feel that the combination of those things say didn't offer us anything, didn't delve into it, prevented our client from having a fair trial. And we feel that based on that, he should be entitled to a new trial.
All right. Thank you so much. All right, the court has heard arguments from both sides. Court listened to all the evidence, internalized it. The court is going to deny the motion for a new trial. All right, and Mr. Cox, are you going to withdraw and someone else is going to do the
Yes,
appeal?
Judge. I'm going to file the paperwork hopefully by either tomorrow or Monday for the appeal, and to withdraw and have the court appoint someone because my client is obviously not able to afford an appeal because he's incarcerated.
All right, so we will make sure that you have an attorney appointed. I don't necessarily appoint the attorney. It's just so you know, it's on a rotation. So whoever is next up on the list who does appeals, that will be the person that will handle your appeal. So people have to actually sign up for the appellate will, and there are a host of conditions and classifications for people who do appeals. So you'll get someone who actually does appeals to represent you.
Do I need to sign up on anything?
No, you don't need to sign anything. What will end up happening is an appellate attorney will be appointed to represent you, and that attorney, if need, will get in contact with you. All right.
All right, thank you very much.
All right, you're welcome. Thank you. Could you hand that to Diana?
We did that one.
No, I'm being asked that he be called up. And then after Trayvon Stevenson, it's going to be Martin Carrion. I'm sorry, that goes in the file. No, is there an issue?
No, Judge, I just, Mr. Stevenson had questions and just, wanted to reiterate what the court wanted in regards to how everything's gonna work out. So I was explaining to him that the felony drug court they will evaluate him first.
Mhm.
If he's not accepted into felony drug court, he will be evaluated by SATF.
Yes,
At that point, if he's in SATF, if there is a letter from the military indicating he's going to go back into the military, at that point, we would present it to the court for his release from SATF.
yes,
However, in the meantime, in additional, we are having a TAP evaluation being done in custody. Now, when the TAP is done and the felony drug court referral goes through, all of that should just fall like in place.
yes,
Is that correct?
yes, that's correct.
Do you
Do
understand?
you
now?
understand? You have any questions about anything?
Will I be getting time served for any time that I sit in the county?
Well, you're not going to prison, so there's no need for any credit for any time served. But if for some reason you're on probation and you get revoked, yeah, you'll get credit for any time served. Okay, all right, thank you.
Thank you, Judge.
Martin Carrion. And there's no application. Court is calling 2023 CR 9561, State of Texas versus Martin Carrion. All right, just 1 second. And Deputy Laura, if you can move them. We're on the record. Could I have parties announced for the record for the state
Jason Garrett, Your Honor.
defense?
A lot of ways for the defense.
And are you Martin Carrion?
I am, Your Honor.
Counsel, have you reviewed all the discovery with your client and did you receive all discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Carrion, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
I did, I have, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No objection, sir.
Mr. Carrion, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of evading arrest, detention, and vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
I do, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Absolutely, Your Honor.
Are you a U.S. citizen?
I am, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
I have, Your Honor.
According to the plea, punishment is to be assessed at 5 years in the prison. There are no applications. The state is taking in consideration 722-427, 716-489, 716-490, 716-491. Did you understand that to be the plea?
I have, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Into the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, state exhibit number 1 with all the attachments, Your Honor.
No objection, Judge, for the purpose of the plea.
All right, states you may be excused. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Court will find that defendant has no, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that the court follow the agreement.
All right, the court will follow your agreement, find you guilty, sentence you to 5 years in the prison, give you credit for any time served, taking consideration 722-427, 716-489, 716-490, and 716-491. Is there anything else with regards to sentencing?
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor, I have.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do, Your Honor.
All right, we can go off the record. How old are you?
I'm 43, Your Honor.
It's time to stop the foolishness, because otherwise you're going to end up at the prison as a habitual. And if you have another felony case and you're labeled a habitual, depending on the type of felony, your minimum is 25 years in prison. Do you understand?
I do, Your Honor.
Do you have any children?
I do, Your Honor.
What are their ages?
I have 7 children. They range from 27 all the way to 15.
15-year-old is not receiving guidance from you. Maybe that's a good thing, maybe not. But if you want to be in their life, you're going to have to be better. You understand?
I do, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge. May I be excused?
Dinah, let me know whenever you need a break. You want a break? All right, yes. All right, everyone, we're going to take a short break so the court reporter can exercise her fingers a little bit.
Oh, you do.